Alabama has one of the least regulated breaking lease frameworks in the country, consistent with the state's overall landlord-friendly approach and strong property rights orientation. The governing law includes the Alabama Uniform Residential Landlord and Tenant Act, Alabama Code, Title 35, Chapter 9A, along with general contract principles. If you're a landlord or tenant in Alabama, the statutory framework provides basic structure while giving landlords broad discretion in how they handle early lease terminations. Let's start with the landlord's duty to mitigate damages. Under Alabama Code Section 35-9A1105, when a tenant abandons the property or breaks the lease, the landlord has a statutory duty to make reasonable efforts to re-rent the unit. Alabama's mitigation requirement is codified within the AURLTA. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. However, and this is important, the AURLTA only applies in certain Alabama jurisdictions. The Act applies in counties with populations above certain thresholds and in municipalities that have adopted it by local ordinance. For many parts of Alabama, particularly rural areas and smaller towns, the AURLTA does not apply, and the landlord-tenant relationship is governed by common law and the lease terms. In URLTA jurisdictions, which include Birmingham, Montgomery, Huntsville, Mobile, Tuscaloosa, and other urban areas, the statutory mitigation duty applies. The landlord must take reasonable steps, advertising, showing, and accepting qualified applicants. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. In non-URLTA jurisdictions, the mitigation duty is based on common law principles. Courts generally recognize the duty, but the standard is less precisely defined and enforcement may be less consistent. Landlords in non-URLTA areas should still make reasonable mitigation efforts, because courts are increasingly adopting the mitigation principle even without a specific statute. But the legal framework provides less guidance. This dual system means that a landlord's obligations when a tenant breaks a lease can differ depending on which county the property is in. A property in Birmingham operates under URLTA with a clear statutory mitigation duty. A property in a rural county that hasn't adopted URLTA operates under common law with less defined obligations. Landlords with properties across multiple Alabama counties should know which system governs each property. Early termination clauses are generally enforceable in Alabama, in both URLTA and non-URLTA jurisdictions. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months rent is typical and enforceable under general contract principles. Alabama courts enforce reasonable contractual provisions and give significant deference to negotiated terms. The state does not cap early termination fees. In URLTA jurisdictions, the early termination clause should be consistent with the Act's provisions, including the mitigation duty. A clause that eliminates the mitigation duty or imposes the full remaining rent as liquidated damages without accounting for mitigation may be more vulnerable to challenge in a URLTA jurisdiction. In non-URLTA jurisdictions, the lease carries even more weight because the statutory framework provides minimal guidance. A well-drafted early termination clause is essential in non-URLTA areas to define the process, the financial consequences, and each party's obligations. Military members have the right to break a lease under the SCRA. Alabama has a significant military population. Redstone Arsenal near Huntsville, home to NASA's Marshall Space Flight Center and the Army's Space and Missile Defense Command, generates enormous rental demand. Fort Novosel, formerly Fort Rucker, near Daleville, is the Army's primary aviation training center. Maxwell Air Force Base in Montgomery, Anniston Army Depot, and various reserve and guard facilities generate additional demand. SCRA lease terminations are regular occurrences across Alabama's military communities. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Fort Novosel's aviation training mission creates particularly high turnover. Students and instructors rotate through on assignments ranging from a few months to a few years. Landlords in the Daleville Enterprise Ozark area process constant SCRA terminations. Redstone Arsenal's workforce includes both military and civilian defense employees. Only the military members have SCRA rights, but the civilian workforce also rotates, creating regular non-SCRA lease breaks. Alabama has enacted protections for victims of domestic violence that allow early lease termination. Under Alabama Code Section 35-9A-158, a tenant who is a victim of domestic violence, as defined in the Protection from Abuse Act, can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid protection from abuse order, either temporary or permanent, or a copy of a police report documenting the domestic violence. The tenant must provide at least 30 days written notice before the termination date. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules, returned within 60 days. Alabama's provision addresses co-tenants. If the victim and the perpetrator are both on the lease, the victim can terminate their individual obligation. The remaining tenant's obligations continue, and the landlord can pursue eviction of the perpetrator if they violate the protection order or lease terms. One important note: Section 35-9A-158 is part of the URLTA, which means it applies only in jurisdictions that have adopted the Act. In non-URLTA jurisdictions, there is no specific statutory domestic violence lease termination right. Domestic violence victims in non-URLTA areas must rely on general contract principles or negotiate with the landlord. This is a significant gap, and landlords in non-URLTA areas should consider voluntarily including a domestic violence termination clause. Tenants in Alabama may break a lease if the landlord fails to maintain habitable conditions. In URLTA jurisdictions, under Section 35-9A-204, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises fit and habitable, maintain structural integrity and essential systems, and keep common areas safe. If the landlord fails to act after receiving written notice, the tenant has remedies under Section 35-9A-40A1, including lease termination. The tenant must provide written notice identifying the deficiency. The landlord then has 14 days to make repairs for non-emergency conditions. If the landlord fails to act within 14 days, the tenant may terminate. In non-URLTA jurisdictions, the habitability framework is less defined. Alabama's common law historically followed the doctrine of caveat emptor. Let the tenant beware. Courts have moved away from this strict position, and most legal scholars agree that a basic implied warranty of habitability exists even in non-URLTA areas. But the scope and procedures are less developed. Tenants in non-URLTA areas who need to terminate based on habitability should provide written notice, document conditions thoroughly, and allow a reasonable repair period. But the legal path is less certain. Alabama also recognizes constructive eviction in both URLTA and non-URLTA jurisdictions. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, failing to address dangerous conditions, changing locks, render the unit uninhabitable, the tenant can treat the lease as terminated. Alabama's climate creates specific habitability concerns that can trigger lease termination rights. The southern part of the state, Mobile and the Gulf Coast, faces hurricane risk. Hurricane damage that renders a rental uninhabitable generally suspends or terminates the lease obligation. The hot, humid climate throughout the state promotes mold growth, pest infestations, and moisture damage, conditions that can constitute habitability violations if the landlord fails to address them. Alabama's abandonment provisions differ between URLTA and non-URLTA jurisdictions. In URLTA areas, the Act provides a framework for handling abandoned property. In non-URLTA areas, abandonment is governed by common law. The landlord should document evidence before re-entering. In both cases, the departing tenant remains liable for damages subject to the mitigation duty. From a practical standpoint, Alabama has a diverse rental market with dramatically different dynamics across the state. Huntsville has emerged as one of the fastest-growing cities in the South and has fundamentally changed Alabama's economic story. The concentration of aerospace, defense, and technology employment at Redstone Arsenal creates a distinctive tenant pool heavily weighted toward engineers, scientists, and defense professionals. When a tenant breaks a lease in Huntsville, re-rental is typically quick, 2 to 4 weeks, given the strong demand. Many Huntsville tenants have excellent credit and income and may be willing to pay early termination fees without dispute when their assignment changes. Huntsville landlords deal with 2 types of lease breaks: SCRA terminations from military personnel and voluntary breaks from civilian defense employees and contractors whose assignments end or change. The civilian breaks don't have SCRA protection, and the early termination clause governs. Having a clear clause with a reasonable fee streamlines these transitions. Birmingham, Alabama's largest metro, has a moderate market. Re-rental varies by neighborhood. The revitalized areas like Lakeview, Avondale, and Highland Park have stronger demand. Mountain Brook and Homewood command premium rents. Other parts of the metro take longer. Birmingham operates under URLTA, so the full statutory framework applies. Birmingham's diverse population, approximately 70% African American, means that damage claims against departing tenants should be applied consistently. Pursuing aggressive claims against some tenants while writing off losses for others creates fair housing risk. Montgomery, the state capital, has a stable market driven by state government, Maxwell AFB, and healthcare. SCRA terminations from Maxwell are routine. Re-rental is moderate. Mobile has a market influenced by the port, Airbus manufacturing, Austal shipbuilding, and healthcare. The Gulf Coast location brings hurricane risk. Storm-related lease breaks are a real possibility. Tuscaloosa, home to the University of Alabama, has a tight student market. Student lease breaks timed to the academic calendar fill quickly. The intensity of Alabama's college culture creates strong and consistent demand near campus. Mid-year breaks take longer. Auburn-Opelika, home to Auburn University, has a similar student dynamic. Fort Novacell's Daleville Enterprise Ozark Corridor has a heavily military market with constant SCRA turnover. The Black Belt region has some of the softest markets in the country. Re-rental can take months. Pursuing the full remaining rent from a departing tenant in a market where the unit might sit vacant regardless is both impractical and legally vulnerable given the mitigation duty. Landlords in the Black Belt should structure leases with shorter terms and realistic expectations. One best practice for Alabama landlords: determine immediately whether each property is in a URLTA or non-URLTA jurisdiction, and build your lease and procedures accordingly. In URLTA areas, the statutory framework provides a foundation. Your early termination clause should complement the Act's provisions. In non-URLTA areas, the lease must be more comprehensive because the statutory framework provides minimal guidance. Your lease is the primary document. Another best practice: document your mitigation efforts meticulously regardless of whether you're in a URLTA or non-URLTA area. Both statutory and common law mitigation duties require reasonable efforts, and your documentation proves you acted reasonably. Keep records of listing dates, advertising channels, inquiry counts, showings, and when you accepted a replacement tenant. A third best practice: for landlords in non-URLTA areas, voluntarily include a domestic violence early termination clause in your lease. The URLTA's domestic violence provision, Section 35(9)(a) 158, doesn't apply in non-URLTA areas, leaving domestic violence victims without a specific statutory right. A voluntary clause fills this gap and protects vulnerable tenants. For landlords near military installations, Redstone Arsenal, Fort Novacell, Maxwell AFB, build SCRA terminations into your business projections. Alabama's military communities generate constant turnover. Efficient make-ready processes, continuous marketing pipelines, and streamlined SCRA procedures minimize vacancy and keep operations running smoothly. Alabama limits the security deposit to 1 month's rent under the URLTA. The deposit must be returned within 60 days of the tenant vacating, one of the longer return periods in the country. In non-URLTA areas, the deposit is governed by the lease terms. If the landlord in a URLTA area fails to return the deposit within 60 days, the landlord may be liable for double the amount wrongfully withheld plus attorney's fees. These rules apply to broken leases and normal move-outs alike. For the complete guide to Alabama breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.